Okay, we're live now. Well, good morning, everyone from Lima, Peru. It's about 10 a.m. And I'm Jose Daniel Amado. I'm the chair of International Arbitration Court of AmCham, Peru. And this is a edition of our Arbitration Unplugged webinar series. We're thrilled to have with us as guest speaker one of the most experts in the world, Sir Gary Bourne. I'm just here to welcome you because this particular event I'll host. That is Elena Gutierrez Garcia. We'll do the introduction of both our guest speaker and the topic that he will deal with. A few words about the format. For those of you who are unfamiliar with the AmCham events, the AmCham webinars, what we do is we give the speaker, whatever time he wants, between 20, 30 minutes, to discuss the issues and his views on the particular topic. And then we, throughout the time that he's speaking, we'll be getting, you guys have access to the chat feature of this platform, and you can make your questions there. Questions will go. The team that we have here in Lima that is led by Roger Rubio, who is another member of the court. I forgot to say that Elena is also a member of the court, AmCham. And so led by Roger, we'll collect all the questions, organize them in a way that they can be transferred to Elena and myself, so we can present the questions on behalf to Mr. Bourne. Without any further delays, the floor to Elena Gutierrez. Elena.
Thank you, Pepe, and welcome all of the participants. It's a pleasure that you join us. You chose to join us today. I know that there's a lot of webinars going on at this precise time. So we're really, really happy that almost 400 of you actually chose us as your entertainment for the evening or morning, wherever you're connecting. It is actually my role, my honor, and my pleasure to introduce our guest speaker, a man who actually doesn't need an introduction, but I will try my best. Guy Bourne is the chair of the International Arbitration Practice Group of Wilmer, Cutler, Pickering, Hale, and Dole, regarded as one of the world's most prominent authority in international commercial arbitration and international litigation. He has been ranked for the past 20 years as one of the world's leading international arbitration practitioners, and he's the leading practitioner in London. He has participated in more than 600 international arbitrations, amongst them 4 of the largest ICC arbitration and several of the most significant ad hoc arbitrations that have taken place in recent history. Mr. Bourne has also published a number of leading work on international arbitration, international litigation, and other forms of dispute resolution, but he's best known for his treatise, International Commercial Arbitration, published by I could go on and on and on because his CV is endless, but of particular interest given the topic we chose for today, I found that he's also the president of the Singapore International Arbitration Center and holds different advisory and court membership positions in other Asian and American institutions. We are actually extremely happy and honored to have him with us to speak about what we could call a side effect that this pandemic we are suffering has actually brought to us. And that is the switch from in-person hearings to virtual hearings, or at least the choice that the pandemic has put onto us. It is not as if they were unknown before COVID-19 hit us. They were definitely not the rule. According to 2018 Queen Mary International Arbitration Survey, 43% of respondents said that they use video conferencing in international arbitration proceedings frequently. 17% affirmed they did it always, 30% sometimes, and only 5% said that they never used video conference in their international arbitration proceedings. But of course, they were basically or mainly speaking about procedural hearings, such as the case management conference that normally occur at the beginning of the arbitrations. And they were not unknown in the evidence hearings. It was already quite normal to have a bit of the hearing taking place virtually. I myself, and probably many of the people who are listening to us today, have arbitrated cases in recent years where a particular fact witness or an expert witness will actually give testimony remotely, as provided for by the IBA rules on the taking of evidence in international arbitration. But it was not the rule. It was actually very rare to see the whole of the hearing going to the cyberspace, taking place virtually. It was not about technology. Technology was there all the time to be used, but was a little bit ignored by us, or at least not optimized to the benefit of international arbitration proceedings. And then, well, you all know what happened. Our normal vanished a couple of months ago, and we had to choose between adjourning hearings indefinitely until a new normal and a new world came in place and allowed in-person hearings, by the way, a world that is nowhere to be seen so far, or hold the hearing entirely virtually. It was a Korean Commercial Arbitration Board, the first institution that published actually a guide for virtual hearings, known as the Seoul Protocol, and they launched it in March 2020. But the fact is that they actually developed it in November 2019, long before the COVID-19 pandemic went global. Many arbitration institutions followed, as you very well know, the ICC, the ICDR, the Madrid Court of Arbitration, and of course, AmCham Peru. They all have published guidance notes on virtual hearings. Some of them are extremely complete, full of annexes, including checklists, suggested clauses, uses of cyber protocols, and even draft procedural orders on how to conduct a virtual hearing. So it seems the fact that at the moment, virtual hearings are part of our professional lives. But how practical are virtual hearings, and what needs to be done to make them work? What challenges do they pose? What know-how do we need to know in order, or do they require? Do we try to replicate in-person hearings with virtual hearings, or are we taking the opportunity to try to make things differently, maybe more efficiently? And most importantly, will they remain in place in the longer term when the pandemic is over? To share his views on this very interesting topic, I now pass the word to our guest speaker, Gary, to which I again thank profusely for being here today with us. And now the floor is yours. Thank you very much.
Thank you very much, both Jose and Lena, for those very kind words of introduction, and also thank you very much for the opportunity, the invitation to be here and speak with your viewers. I appreciate the opportunity very much, and I hope as well that you and all the viewers are safe and healthy in these unusual times. These unusual times, though, have created themselves opportunities for new types of hearings, new types of arbitration, in a sense. And although there are countless webinars, countless guidelines, countless email chains about virtual hearings, perhaps it's useful to have a kind of summary or encapsulation of the various developments that have occurred, the different types of issues that arise because of virtual hearings and the difficulties with having in-person hearings, and some practical thoughts about the challenges, but again, on the other hand, the opportunities of this new creature, virtual hearings. As we all know, technology has been available for some time to do many aspects of the arbitral process remotely without being in person. To some extent, as Lena has already pointed out, we have for years, maybe even in some cases decades, been using technology, whether telephonic or video conferencing, for aspects of the arbitral process. I'm revising the third edition of my treatise at the moment. The first edition was in 2009, and there was a footnote there that raised a question, citing some commentators, some European commentators, as to whether or not email service of a request for arbitration or email transmission of documents in the course of an arbitration would be valid. It's a little bit unusual, but it really was only 10, 11 years ago that there were thoughts, there were doubts about whether or not even the use of emails to communicate would be valid. The world has changed a lot, and as you can imagine, the third edition of my treatise, which comes out in the next few weeks, addresses all those changes. But some of the bigger changes have been in the context of both telephonic and video conferencing aspects of the arbitral process. I think we've all participated, both as counsel and also, or alternatively, members of a tribunal, in telephonic case management conferences or procedural meetings. I think, although one can again go back to some of the older commentaries and textbooks, to some older practitioners who will emphasize how important it is to have an in-person first meeting of the tribunal so that the parties in the tribunal can bond in some sort of physical sense. Most of us have become accustomed in international cases, even if they're only regional and not involving parties in different continents, to simply for the sake of efficiency have a first procedural meeting telephonically where the parties can, in a sense, get to know each other, can lay out their procedural positions to the tribunal. The tribunal can begin to organize the case. And I don't think anyone has ever had the slightest doubt but what a procedural conference, even one of some hours, 3 or 4 hours, couldn't be done perfectly well by conference call as opposed to in person. I think also, as Lena mentioned, the use of video conferencing, less telephone conferencing, but video conferencing to hear a single witness or perhaps a couple witnesses in an arbitration was becoming more frequent. It was perhaps not as frequent prior to the pandemic as the use of telephonic conference calls for case management conferences, but still, I think many of us had experience with a witness testifying remotely. We would have a hearing at which the tribunal and the parties, counsel, were all present in a single physical location, but a witness, whether because of visa restrictions, because of illness, because of other personal circumstances, couldn't or wouldn't be present physically at the hearing, would testify remotely. And the counsel would, in the hearing room, in the presence of the tribunal, cross-examine the witness, who would appear, in a sense, virtually, appear on a television screen, or more likely set of screens in front of counsel and the tribunal. And cross-examination would proceed in very much the way that it would if the witness were physically present in the hearing room. And by that, I mean the witness's testimony would be inserted in the course of the hearing, which took place otherwise in person, exactly as it would have without any remote testimony. And in that sense, the witness was really brought into the hearing room through video conferencing. And nothing really changed in the manner in which the hearing was conducted. Sometimes there might be issues with respect to, does the witness have the documents there, and arrangements would be need to be made to ensure that a bundle was either couriered or electronically transmitted to the witness, so that if there were going to be cross-examination questions using documents from the record, the witness would have the documents. Arrangements needed to be made often to ensure that the witness wasn't coached. Sometimes counsel who was cross-examining the witness would insist upon having someone physically present in the witness's conference room or wherever the witness chose to give evidence from. But all of this was really, in a sense, extending the hearing room, the in-person hearing room, and bringing the witness into it in that way. The pandemic has changed things, as we know, fairly radically. In most jurisdictions, the notion of an in-person hearing is, at least for the time being, out of the question, and likely for the foreseeable future, either out of the question or at least open to very serious doubts. Social distancing effectively makes it impossible to have an in-person hearing. The week before lockdown was announced here in the UK and also in a number of other European jurisdictions, I was at a hearing in Sao Paulo in Brazil. There were 4 parties involved, and there were roughly 50 lawyers, witnesses, arbitrators, translators, and the like in a single hearing room. And although we weren't aware of it at the moment, it was a perfect place at which the pandemic could have spread. Fortunately, it didn't, but the notion today of having an in-person hearing of anything like that, I think, is out of the question. A hearing, even with just the tribunal in a single physical location, is subject to very serious doubts. In all likelihood, all members of the tribunal, all counsel, all witnesses will be at home in separate locations. And in that sense, a virtual hearing, which is what we talk about today, a virtual hearing really is fundamentally different from the remote testimony that previously we all experienced. In almost every major arbitration, there would be some element of remote testimony, but typically just one or a couple witnesses, typically just one procedural telephone conference, not the entire hearing. And what now is both being contemplated, but also being put into practice literally every day, is a complete virtual hearing, meaning from the very beginning, introduction of the tribunal, housekeeping matters, opening and closing, till the very end of the hearing, through all the examination of witnesses, fact and expert, and closing submissions, and then closing of the oral proceedings. The entire hearing is conducted virtually through one of the various software applications that are available. What those hearings, I say, are being done every day. You can, for example, watch an ICSID hearing, a 3-day hearing, which was conducted virtually, the tribunal on different continents, the witnesses in different locations, counsel on different continents, but all of it with the careful supervision of the ICSID counsel and technical assistance, enabling the hearing to be conducted without any complaints from counsel or the parties on either side, and with the tribunal believing that it had fully heard the parties' submissions and understood the witness testimony. And one certainly reads about preparations being made for those sorts of virtual hearings in many other cases. I've participated myself in virtual hearings, cross-examining witnesses by video conference, and can attest personally to the practical utility, feasibility of conducting a hearing in an entirely virtual manner. All that said, there are both a number of legal issues that arise and also practical issues, logistical issues, and in a sense, tactical issues or practice pointers that I think it's worth discussing. I'll try and discuss the legal issues first and then wrap up with some practical pointers or observations from my own experience about the challenges, but also the opportunities that virtual hearings present. Let's start first with some of the legal issues. So if both parties are content, as they were in that ICSID case that I mentioned, to proceed by way of a virtual hearing, there really aren't many difficult legal issues about how one conducts such a hearing. There aren't objections from either party that they're being denied an opportunity to be heard or that they're being denied a real hearing. And thus, if you have consent on both sides, and the tribunal, of course, is happy to proceed in that manner, then a virtual hearing really raises practical issues as opposed to legal issues, insofar as parties might have some objection or right to object to a virtual hearing. They would have waived that right by consenting formally to a virtual hearing. But the world being what it is, parties don't always want to proceed with a virtual hearing. And you can imagine at least two different types of scenarios. One where the claimant, for example, is eager to go forward with its claims. It wants its claims heard, but the respondent, as respondents sometimes do, prefers not to have the arbitration proceed immediately and raises objections to a virtual hearing, either because it would prefer the case to go slowly, or alternatively because it genuinely wants an opportunity for an in-person hearing. In those circumstances where one party, and you can also imagine the reverse circumstance, a case where the respondent, perhaps for tactical reasons, perhaps for other reasons, is content with a virtual hearing. Alternatively, the claimant insists upon an in-person hearing because it believes, rightly or wrongly, that the physical presence of the witness in front of the tribunal, or the witnesses in front of the tribunal, is important to establishing its case, to presenting its case as positively as possible. So that one scenario that we need to consider from a legal perspective is one party objecting to a virtual hearing. An alternative scenario, and I'll come to that in a moment, an alternative scenario, of course, is in a sense even more extreme. Both parties might object to a virtual hearing. Both parties might take the position that they need an in-person hearing, that their case demands an in-person hearing, and that the tribunal cannot and should not order a virtual hearing. And that's an alternative scenario. In both cases, there are two types of issues, legal issues, I think, that arise. The first involves a question of the law of the arbitral seat and relatedly any institutional arbitration rules that might be applicable in that particular case. In many instances, institutional arbitration rules give both parties the right to a hearing if they so request. They don't give both parties the right to as many hearings as they want or as long a hearing as they wish. They don't give a party a right to a hearing at any particular time that they demand, but most institutional rules provide that if one party requests, the tribunal shall, in mandatory terms, organize and provide that party a hearing. National law, Article 24 of the UNCITRAL model law, other national arbitration legislation often does pretty much the same thing. Often national arbitration statutes provide that if a party requests a hearing, then unless the parties previously have agreed to a documents-only arbitration, then the tribunal shall, again in mandatory terms, provide a hearing. And again, it doesn't mean that the tribunal shall provide as long a hearing as the party requesting a hearing wishes, or a hearing every time the party demands one, but at some point in the arbitration, parties are in most countries entitled to a hearing. The question arises, well, is a hearing only the kind of oral, in-person hearing that existed, and frankly, that was the only thing that existed when the model law was drafted in 1985? Or does a hearing include what I've been talking about, what Lena introduced, a virtual hearing where nobody is physically present with anyone else, and the witnesses, importantly, counsel, importantly, are not present in front of the tribunal? Is that a virtual hearing where all of us are connected only the way that you and I now are connected? Is that really a hearing? Are you hearing me? And are counsel being given an opportunity to be heard if it's only through the internet, if it's only by way of virtual remote technology? There are German authorities that conclude a hearing really does mean the old-fashioned kind of hearing where you could see the whites of their eyeballs, where you could be in the physical presence of the tribunal, the sort of physical confrontation that comes from an in-person hearing. Most authorities, I think, have a different view, especially these days. By these days, I mean these pandemic days. Most authorities, I think, would conclude that a hearing includes any mechanism where you have the opportunity for interaction, both audio and visual, in real time. That a hearing includes the opportunity to have the tribunal put questions to you, the opportunity for you to see the tribunal as you make your oral submissions, the opportunity for a witness to testify directly to the tribunal and to respond to questions in real time. I think most authorities have in the past concluded with respect to remote testimony, and increasingly in pandemic days, although there are few decisions thus far, concluded that an entire virtual hearing is in fact a hearing and not something else. There were authorities in both the annulment and the recognition context prior to the pandemic rejecting arguments that remote testimony didn't provide parties an opportunity to be heard or an opportunity to present their case. And implicit in those conclusions, I think, is that those witnesses were testifying at a hearing, even if they were testifying remotely. And the same analysis ought, in principle, to apply under both institutional arbitration rules and under the model law and under other national arbitration legislation. A virtual hearing, as the name suggests, really is a hearing. But even if a virtual hearing is a hearing, that doesn't mean that it necessarily satisfies other requirements that both the model law and the New York Convention, Inter-American Convention, impose. Both the model law in Article 18, the New York Convention, and other provisions, Article 5.1b, guarantee the parties an opportunity to be heard and equality of treatment. Indeed, the model law in Article 18 guarantees a full opportunity to be heard. And so even if a virtual hearing is a hearing, does it provide an opportunity to be heard? And does it provide equal opportunity to present your case? The better view on both those, again, I would suggest in many circumstances, but I emphasize many, not all, many circumstances, is that parties do have a full opportunity to be heard in a virtual hearing, and they do have equality of treatment. Obviously, if both parties are appearing virtually, they're being treated equally. But there may be exceptions. One party may not have reliable internet access. One party may not have the technological faculties or access to resources that enable it to be heard the way that the opposing party does. And in those circumstances, I think a tribunal must think very carefully about whether or not a virtual hearing is fair, whether it accords with Article 18, and whether, if such a hearing were conducted, it would result in an award that could not be annulled or denied recognition. Similarly, there may be circumstances, although in many cases, as my previous comments suggest, in many cases, a virtual hearing does indeed give both parties an opportunity to be heard. Opening submissions, closing submissions can be made just as well virtually in most respects as they can in person. PowerPoint slides and other demonstratives can be used either on Zoom or WebEx, the way we're using today, as they could be in person. Indeed, in some ways, at least arguably, you have more of the tribunal's attention, not less of the tribunal's attention during a virtual hearing. And thus, I think in the vast majority of cases, objections to a hearing on the basis that it denies a party the opportunity to be heard really will be difficult in these pandemic times. And there are two additional points that I think really underscore that conclusion. One is that national courts in many jurisdictions, Singapore, the United States, England, I'm sure in Latin America, are going forward with hearings in a virtual sense, where national courts themselves are conducting virtual hearings subject to constitutional guarantees for due process or natural justice. It would be a very peculiar result to say that arbitrations could not also proceed with virtual hearings. The adaptations that have occurred in national courts are all the more likely to be accepted in the context of international arbitration, where you have the difficulties of distance and visa health restrictions that exist today. And the second point that I think it's worth making is that one has to look at what happens if there are not virtual hearings. And if virtual hearings are not permitted, then in the pandemic era, one can't say whether or frankly if in-person hearings will be permissible, will be possible in the foreseeable future. And if a virtual hearing inhibits, I don't think it does, but if a virtual hearing inhibited a party's ability to present its case, then not having any hearing at all and denying the parties any opportunity to be heard seems to do so even more pointedly. And thus, I think in the vast majority of cases, certainly in many cases, objections based on the denial of an opportunity to be heard or denial of equality of treatment are also unlikely to succeed. Parenthetically, there were decisions from prior to the pandemic which reached much the same conclusion, albeit only involving remote witness testimony as opposed to an entire hearing being conducted virtually. But as we're going to see as I turn very, very soon to the issue of logistics, in fact, it's exactly that witness testimony that I think presents the greatest logistical and practical difficulties. And thus, if courts were prepared to uphold awards where there had been remote witness testimony prior to the pandemic, I think virtual hearings after the pandemic has come upon us are particularly likely to be upheld. With that legal background as a starting point, I'd like to turn then to logistics. Having seen that as a matter of law, as a matter of national arbitration law, institutional arbitration rules, virtual hearings are permissible, let's look at the question of whether in fact they should be ordered, and if so, how that should be done. I think in circumstances where one party objects and the tribunal carefully considers the fairness, the equality of treatment, the logistical and practical problems that one party might face, a tribunal will often be on solid ground in ordering, notwithstanding the objection, a hearing, a virtual hearing to go forward. I think if both parties object, it's a much more difficult question. I think I at least am a believer in the notion, if you ask the question, whose arbitration is it? The right answer is it's the party's arbitration. And therefore, even if the tribunal thinks that the arbitration could go forward, the better view is that it shouldn't go forward. the tribunal ought not to overrule the joint wishes of both parties in any but the most extraordinary case. But how then ought a virtual hearing to be organized? I think my experience, and the experience both at the Singapore International Arbitration Center and ICSID has been that virtual hearings require a lot of preparation working with the arbitral institution. And by that, I mean, the parties need to obviously agree upon a single provider, whether it's Zoom or WebEx or BlueJeans. There are a number of providers that I think many have had positive experience with. ICSID has used WebEx. I have used Zoom, and in both circumstances had quite good experiences in terms of connectivity, in terms of the ability to see the tribunal, the witness, and so forth. That said, there are important things that should be done before one jumps into a hearing, whatever software application one uses. I think as often occurs in these sorts of webinars, test sessions, making sure that everybody's equipment is compatible, making sure that there are no unexpected technical glitches are absolutely essential. I think it's also important to have IT staff monitoring the call, available to assist with technical questions, telling somebody to unmute their microphone in the most, the easiest example, but dealing with other problems if they should arise. One has to also be flexible and expect the worst. I had one virtual experience where, notwithstanding great preparation, one of the participants was unable to connect at a critical moment, and the events had to be rescheduled. But with flexibility and advanced practice and preparation, the virtual hearing certainly can be conducted perfectly well. However, there are a number of things that ought to be considered and done, and there are also a number of very important differences between a virtual hearing on the one hand and an in-person hearing on the other hand. First, in the category of preparation, it's critical to remember that all of the members of the tribunal, but also all of the members of counsel team on each side, are going to be by themselves, or virtually always will be by themselves. That means for tribunal members, one needs to arrange a means of consultation so that if issues come up, as inevitably they do during the hearing, the tribunal can consult privately before the presiding arbitrator makes a ruling or a request of the parties. Most software applications have breakout rooms or private chat functions that enable the tribunal to communicate well. I think it underscores the benefits, though, of having IT support during the hearing so that the tribunal can be absolutely certain that its internal deliberations and consultations are entirely private and confidential. But equally important that counsel on both sides are able to consult with their respective teams and, of course, with their clients. I've done a couple cross-examinations virtually, and it's a very different experience to cross-examine a witness when you're sitting by yourself at home without somebody next to you to point out the contradiction in the witness's testimony that has just occurred, or point out a bit of the document that you ought to refer the witness to, or remind you that the tribunal is raising its hand to query something that the witness has said. Being alone changes the experience of cross-examination from the counsel's perspective, very importantly, but also underscores the importance of having a private breakout room for the members of counsel on each side, and a private chat line whereby you can communicate seamlessly with the members of your team. That brings you to, I think, inevitably a hardware question. Almost always, a virtual hearing requires not one screen, but either 2 or 3 screens. One screen for the main event, the hearing, but another screen for your private breakout room, and then potentially a third screen for documents. Documents are one of the more challenging aspects of a virtual hearing. Almost always, you'll want a PowerPoint or something like that for your opening and sometimes closing submissions. Almost always, you will want documents to cross-examine a witness or to show to the tribunal. And finding a technological way to present the documents seamlessly can be challenging. Depending on the size of the documents, being able to call the documents up in real time and then to navigate through those documents seamlessly without time lags can be very challenging. Often, ensuring that all members of the tribunal and witnesses have hard copy, either couriered to them or printed out locally, is a useful fallback. And at least in my experience, often resort is made to notwithstanding a virtual hearing, is made to hard copies of documents, which are sometimes easier to access while you're participating in the virtual hearing. Alternatively, as I mentioned previously, you can have another screen, sometimes with its own access to documents that have electronically been distributed prior to the hearing. Advanced preparation on all this is absolutely essential. No matter how many cross-examinations you've done, I've done more than I like to remember. No matter how many you have done, practicing how a virtual cross-examination works, how the documents are accessed, what the inevitable time lags are as you refer to bits of the document, is absolutely essential. But it's also entirely doable. In that regard, though, a couple things I think are important. One, as you can probably tell from this webinar, people's attention spans are a lot shorter virtually than they are in person. I think most people's experience is that after 45 minutes or so, people really get drained. There are psychologist studies as to why that might be so, why staring into a television screen is harder than looking into a room full of people, why the time lag between the visual and audio cues that you're getting somehow disorients us. But whether or not those hypotheses are correct, I think everyone's experience, certainly my own personal experience, is that a virtual hearing is much more demanding, much more draining than an in-person hearing. Certainly in-person hearings are hard, depending on your case, but virtual hearings are even more exhausting in a sense. And as a consequence, I think what many tribunals have found and what many counsel end up doing is many more breaks. Don't go for more than 45 minutes, an hour and 15 minutes at the very outside. Don't aspire to the traditional 6.5, 7, sometimes 8 or 8.5 hours a day. Instead, a shorter time frame. It depends on some other factors I'm going to mention in a moment, but 4 hours, 5 hours is probably a more realistic estimate in many cases. One of the things about arbitration, of course, is that it's infinitely flexible. Every arbitration is like a snowflake. It's unique. You can therefore design your own sitting times, your own hearing times, but time takes more out of you virtually in I think most people's experience, and therefore you need shorter hearing days, which in turn implies longer hearings. It's harder to fit as much time into 5 days as might have been the case in in-person hearings. Related to that is the question of time zones. If you're all in the same region, Peru and Chile, United States and Peru, the UK and France, things are straightforward in one sense. You're all beginning and ending at pretty much the same time. If you have a hearing that is Singapore and the United States, or the United States, West Coast, and London, then time zones become a real issue. It means almost inevitably that somebody has to get up way too early, or somebody else has to stay up way too late. In some circumstances where you have parties in Asia, say Hong Kong, Europe, say France or Germany, and the United States or Peru, it may be very difficult to have a virtual hearing simply because of the constraints that time zones present. And those sorts of things need to be considered very carefully. It's also very important to ensure equality of treatment when you're dealing with time zones. If you're asking counsel to work until 3 in the morning, you need to make sure that accommodations are made for that, and also that the inconvenience, the personal inconvenience is distributed fairly and equitably between counsel. In some cases, counsel may not have objections. They may routinely, as some of us may do, work until 3 in the morning, and therefore it may not be an issue. But in many cases, it is an issue. And therefore, time zones can present real constraints for hearing times. I think apart from that, ensuring good communications within counsel's teams is very important. It's difficult to have your attention focused on the computer, on the virtual hearing, and at the same time be looking at your WhatsApps to be seeing what your colleagues are telling you you've just made a mistake on, and so forth. Figuring out a way in real time to have seamless communications is critically important. I think the takeaway from all these logistical aspects of virtual hearings is that with careful preparation and practice, virtual hearings can be effective. They can provide a reasonable way of examining witnesses, and certainly an entirely adequate way of making opening and closing submissions. I can tell you from personal experience that examining witnesses virtually is very different from doing it in person. It's one thing to control a witness who may be eager to make long speeches or avoid the question. It's one thing to try and control a witness like that in the presence of the tribunal, where you can see how the tribunal is reacting to the witness's speechifying on the one hand, or alternatively to what the tribunal may regard as your rudeness and harassment of the witness if you try and control on the other hand. It's also difficult because of the time lag and because of the difficulties of speaking over a witness virtually to control a witness. And thus, careful practice and anticipation of the kind of issues that may arise in cross-examination is critically important. I think it's also important to think very carefully about how you navigate among documents if you're cross-examining a witness, where the cross-examination requires reference to a number of documents. It's one thing in an in-person hearing to have a bundle or 2 or 3 bundles of 100 documents or so in front of the witness, where you can jump from one document to another relatively seamlessly. It's something else where not just you, but the witness and the tribunal need to navigate among different documents virtually. That can be much more challenging, and you need to think very carefully how you structure your cross-examination, whether in fact you want to use as many documents as you would ordinarily use, or whether you need to take a different approach. I think with that background, I've hopefully provided both food for thought and food for questions if there are those from the audience. And more than happy to address any aspect of what I've talked about or any questions that those of you in the audience about virtual hearing.
Well, thank you very much, Gary, for such an enlightening and also very comprehensive talk. And well, certainly we have many questions. And as I told you before, the format that we're trying to use is that even though Elena and I have a few questions ourselves, we actually give the floor now to questions that come from the audience. So I'll try to read to you the first question that I have here. By the way, the questions have been sort of gathered and identified by a group of people within AmCham, and Professor Rubio is coordinating the questions that actually come to us. So let me give you the first question. It comes from Jackson Kern. I will read it to you. Basically, I believe that it comes from the perspective of the tribunal, but it says, what if a tribunal reasonably concludes that it has the power to a virtual hearing at parties' objection, but the case is nonetheless arguable and not clear-cut? So what should the tribunal do under those circumstances, in your opinion?
So as I mentioned before, and it might sound a little glib, but it's not. Every arbitration, like every person, is like a snowflake. Everyone is unique and has its own characteristics. If a tribunal concludes that there are reasonable prospects of being able to conduct a virtual hearing fairly and allowing both parties an equal opportunity, a full opportunity as well to present their cases, but it's not convinced of that, and if one party objects, then in a sense, the easy course for a tribunal is to hold off. The tribunal obviously doesn't want to make an award that is subject potentially to annulment or non-recognition. Although, as I described previously, the weight of authority thus far has been to reject challenges to awards for the use of remote testimony. And although national courts themselves are conducting virtual hearings, there is some basis for concluding that, at least in some jurisdictions, there may be a risk of annulment and risk of non-recognition, particularly if one party has a reasonable basis for claiming that it would be denied an opportunity to be heard. And if the choice, therefore, is between exposing an award to annulment or non-recognition by going forward now, and on the other hand, just waiting a couple months and having an in-person hearing, it seems hard to say one shouldn't wait and see what happens. That, though, I really think is, in a sense, kicking the can down the road, because what happens in a couple months? If you can have an in-person hearing, then you have an in-person hearing. But in a couple months, one then, I think, faces again even more pointedly the question, how reasonable are those doubts? How reasonable is the fear that an award could successfully be challenged? And I think then, if a tribunal is looking at justice delayed indefinitely, an arbitration put on hold for an indefinite period of time, then a tribunal really needs to confront squarely the choice between a virtual hearing and no hearing at all for the indefinite future. And I think I think that latter choice is a very unsatisfactory one. One thing I've seen some tribunals do is to schedule a hearing date, not order a virtual hearing now, but to schedule a hearing date in the future, leaving open the question whether it will be in person or virtual. Scheduling a hearing date, a fixed hearing date, so even if they have suspended the arbitration in a sense, decided they will not go forward with a scheduled in-person hearing, they don't indefinitely postpone the arbitration. Instead, they fix a hearing date, a reasonable time in the future, hoping that in those circumstances, in-person will be possible or some version of in-person will be possible. But if not, a virtual hearing will be conducted. And I think that isn't necessarily the only approach one can take, but I think in the current circumstances, that is, in a sense, the least that one could do as a tribunal.
Thank you, Gary. There is many of the participants today seem to be worried about potential confidentiality breaches that may occur during virtual hearings. The questions we've been receiving vary from the hacking of the virtual hearing, the RB leaks of the actual hearing that may be recorded for further. So the parties can actually further after they look at it, can be leaked. What can the tribunal do about this? What would you do if, or what have you done in order to protect these cases? And to end the question, do you think that there can be that could be a reason to deny the conducting of a virtual hearing because of the sensitivity of the case?
I think those are fair questions. And even before the pandemic, there were a number of concerns about cybersecurity and the risk of hacking and so forth. There are protocols that have been proposed. I think the New York Bar Association proposed a protocol for cybersecurity. And there are certainly a number of measures that were proposed with respect to written submissions, which raise confidentiality concerns as well as hearings prior to the pandemic. One of the reasons that ICSID prefers WebEx is that it has a very high degree of cybersecurity. The World Bank uses WebEx for other applications and has had very positive experience with security in that respect. And therefore, if one wishes, one can choose a software application where security from hacking is all but assured. Obviously, there are no guarantees in life. The PCA was hacked during one of its well-known state-to-state arbitrations. And if a sufficiently motivated state wanted to intrude on a hearing, a virtual hearing, no doubt they could do so. On the other hand, no doubt they could do so on an in-person hearing. So I'm not sure that one is really changing the game that much. There have been complaints or concerns about certain uses of Zoom. I think Zoom has moved fairly aggressively to try to address those complaints, but the reasons I mentioned having IT consultants involved, IT support involved in the virtual hearing is in part because of cybersecurity, to make sure that since we lawyers, and whether we're counsel or arbitrators, are not really going to be expert in ensuring confidentiality, make sure that we employ proper experts to provide a level of confidentiality that satisfies the parties. I would be quite skeptical if a party resisted any virtual hearing on the grounds of confidentiality. It seems to me that if particular aspects of the hearing were especially confidential, special confidentiality security regimes could be adopted for that. For the hearing itself, generally, I think ICSID's experience with WebEx, other people's experience with different applications ought to provide a sufficient degree of comfort for both tribunals and parties in the overwhelming majority of cases.
Thank you, Gary. We're also getting a line of questions. Let me read to you a question by Alonso Mayordomo. It's a question, basically, I'll just read it to you. In international and also domestic arbitration, where every single party in an arbitration are located in different places or more than one place in any event, how can the parties on the tribunal assure that the witnesses or experts are replying the questions by themselves, not receiving any help?
Yeah, that's an excellent question. It's of course a question that comes up also in in-person hearings. Tribunals rightly instruct witnesses when they take the inevitable coffee break or lunch break, or their testimony spans a couple days, not to confer with members of their team, not to receive advice or instructions about their testimony, and measures sometimes need to be taken to implement that. In a sense, the risk is more pointed in a virtual hearing, because at least theoretically, I could have somebody sitting over here telling me how I'm supposed to answer your question, and none of the viewers would see me looking for instructions. I've talked to some arbitrators who think they would be able to tell if a witness was being coached from off camera, or as someone else put it, had a display screen that was telling them what answers they should give. I suspect that most instances of coaching, even without any steps to police the matter, would run a fairly high risk of being revealed just through how the witness behaves on the webcam. Obvious delays, obvious looking off in other directions, and so forth. I think most tribunals would detect. That said, for those who are particularly concerned, there are cameras that have 360-degree field of vision, and they can certainly be installed in the witness's room, so that one would be able to see the entire surroundings of the witness. Tribunals ought not to hesitate in ordering that kind of technology be used if a party believes that it's particularly important to do so. I haven't seen that done, to be honest. I think in most cases, although historically, when witnesses testified remotely, parties often insisted on a lawyer or somebody from their staff going to the witness's physical location to police their testimony. I haven't seen that issue being pushed that hard in virtual hearings. That said, I think if a party was deeply concerned about a particular witness and the risk of coaching, technological steps exist that would enable one to deal with it.
Thank you, Gary. Of course, we do have a recurrent question. One participant wants to benefit from your crystal ball. So please let us know, what does the future hold for virtual hearings when the pandemic is over, which is very, very soon?
I hope my crystal ball says that the pandemic is over very, very soon. My ball is a little clouded in that particular version. I'm not sure I'm positive about that. What I do think is true, though, what I think is true is that hearings are going to be different after the pandemic than before. I think, and I think this is early days, and what's more important isn't what I think, but what everybody on this webinar thinks. I think experience with virtual hearings will demonstrate that for many cases, they are doable. Because they're doable doesn't mean they should be used in every case, even if you can have in-person hearings. But I suspect that in smaller cases where the expense of putting together a physical in-person hearing is large in comparison to the amount in dispute, virtual hearings actually provide an important enhancement of the adjudicative process, the arbitral process. Virtual hearings, our experience with virtual hearings provides a means through which international arbitration can do exactly what it's supposed to do, namely resolve disputes more efficiently and expeditiously than the alternative means. And I think if you have a dispute for $100,000, $1 million, even $5 million, with parties from different parts of the world, where the expense of putting together a hearing is, in comparison to the amount really in dispute, excessive or disproportionate. What we've learned from virtual hearings in the last months, what we will learn in the coming 3, 4, however many months, provides a really important enhancement, advance on how we traditionally have arbitrated. In that respect, I'd like to make one additional point about what a virtual hearing really is. When we think about virtual hearings, we think inevitably about how to replicate, how to duplicate a real hearing, an in-person hearing. But we ought to think more creatively and flexibly. A virtual hearing shouldn't just replicate an in-person hearing. A virtual hearing can, instead of being a concentrated set of days, 8 hours a day, 5 days for a single week, a virtual hearing can be a rolling set of sessions over, for example, a 2-week period of time. This is especially useful if you have time zone problems, but you don't need, when you're done with one witness, to immediately start another witness. You don't need, as soon as you've finished with opening and closing submissions, to jump into the first witness. You can schedule the hearing in a much more flexible way, a rolling set of sessions on different days to accommodate what is most useful to the tribunal and what is most convenient to the parties. And I think if we think about virtual hearings in that way, not as a carbon copy of an in-person hearing, but as a new opportunity to design the arbitral process as we've always designed it in other respects, in a more flexible way that better accommodates the parties' needs, we can actually use them to give parties a better, not a worse opportunity to be heard.
Thank you very much, Gary. Well, we have a bunch of questions here, but I have a question here by Sandra Gonzalez. Basically, she's concerned about arbitrators' liability. Let me read it to you. If a physical hearing is provided for in the procedural order, but now it is impossible to have such a physical hearing, or one party requests to move to a virtual hearing, the other party objects. Do you think that there is any room for the tribunal to decide outside the order due to arguments such as new circumstances, the like?
So it's a great question, unsurprising from Sandra. A couple responses. First, I really wouldn't think about this in terms of of arbitrator liability. Most national laws, most institutional arbitration rules provide fairly generous grants of immunity for arbitrators for acts conducted in the course of their adjudicative function. And so I don't think that the risk of financial responsibility for an arbitrator is a very significant one. That said, I do think exactly the same kinds of concerns arise with respect to potential annulment of an award, non-recognition of an award. And then the hypothesis is, suppose the tribunal has pre-pandemic issued a procedural order providing for an in-person hearing at a particular date. And now one party wants a virtual hearing, the other party objects. I think in those circumstances, the fact that a procedural order had previously provided for an in-person hearing should not provide any reason to prevent the tribunal from ordering a new virtual hearing. Arbitral tribunals have the power to amend, to change their procedural orders. They have broad procedural discretion in the conduct of the arbitration. And if a hearing that they have previously ordered stops being possible, stops being convenient because of the pandemic, or frankly, because of other circumstances, they have, at least in my view, very broad power to provide for a new, different kind of hearing. Arbitral tribunals certainly, without question, have the power if one party becomes unavailable unexpectedly for a good reason, or because one of the arbitrators passes away or becomes ill or incapacitated, to reschedule a hearing that was previously organized. And I don't think any different question arises with respect to canceling or recognizing the impossibility of a physical hearing because of the pandemic. For all the reasons I mentioned previously, I don't think there are, in most cases, not necessarily all cases, but in most cases, I don't think there are legitimate grounds to object to a virtual hearing. And therefore, in answer to Sandra's question, I think the tribunal could amend its previous procedural order and order a new virtual hearing in place of a physical hearing that it had previously scheduled. I think if it's going to do that, just as in a case without a procedural order, it should satisfy itself very carefully that, in fact, the parties will have a full opportunity to be heard virtually, and that the parties can be treated equally. But if it does so, if it satisfies itself with respect to those questions, I don't think its prior procedural order should prevent it from conducting a virtual hearing.
Thank you very much. We move on now to enforcement of awards that have taken place after a virtual hearing was actually the case. This comes from Karina Kresh, and I read, Professor Galbon, you have stated that there is a chance the award is not enforceable if the hearing takes place online for reasons of lower quality of the internet by one of the parties, as an example, hence making the hearing probably unfair for this party. However, from the moment that both parties agree on having a virtual hearing and the hearing indeed takes place, on which ground do you think an award could not be recognized? So which of the letters of the New York Convention's Article 5 would we actually argue upon if you were to have to take on this case as a counsel?
So I think the two obvious grounds for an objection would be Article 5.1b and Article 5.1d. Article 5.1b, of course, provides that the parties must be given notice. Well, it provides that an award may be denied recognition if a party hasn't received notice, or if it hasn't received an opportunity to present its case. And I think the argument there would be that a virtual hearing denies an opportunity to be heard. For all the reasons that I have previously explained, I don't think that's a very persuasive argument in many cases. There may be circumstances where, because of the particular nature of the witness testimony or the witnesses, because of the peculiar character of the subject matter of the arbitration, because of difficulties with access to the internet or technical problems, that conclusion might not be true. But I think in many cases, probably the vast majority of cases, parties would have an opportunity to be heard under Article 5.1b. Article 5.1d allows for non-recognition if the arbitration wasn't conducted in accordance with the agreement of the parties. We've already talked briefly about the possibility that institutional arbitration rules might require a physical in-person hearing. If that's what institutional rules required, and the tribunal didn't abide by that, didn't conduct an in-person hearing and instead conducted a virtual hearing, the award would potentially be exposed to non-recognition. For the reasons I've also described, I think most institutional rules wouldn't provide much support for that result. Most institutional rules, ICC rules, UNCITRAL rules, SIAC rules, speak only of hearings or oral hearings. And as I've said previously, a virtual hearing is a hearing, not something else. And it's also not just an oral, but also a visual hearing, an audio and a visual hearing. So I think those are difficult arguments. You could imagine institutional rules that, for whatever reason, provided for a in-person hearing. You could also imagine a party's arbitration agreement that provided for an in-person physical hearing. I suppose if one were being creative, one might look to arbitral provisions, arbitration clauses that provide for hearings in a particular physical location, as implying that there has to be a physical hearing, not a virtual hearing. A virtual hearing isn't conducted in a particular physical location. But I think those are challenging arguments. Those, I think, would be the two obvious bases for non-recognition under Article 5.1a. You could also try Article 5.2b, public policy. You might imagine some sort of public policy against virtual hearings. With most countries' courts providing virtual hearings, it's not so clear to me how one would say that a virtual hearing violates public policy, but as they say, public policy is an unruly horse. You never know where it will take you once you get on it. And so maybe it takes you to an in-person hearing instead of a virtual one.
Thank you, Gary. Well, we're running out of time, unfortunately, and we still have a number of questions from the audience. He said I would ask you to kindly provide us with any type of final message on the issue or final remarks, if possible, to all the community that is really following this webinar, and also very interested in what you have to say about the topic. Please.
Thank you again, Jose. In terms of final remarks, I'd like again to thank AmCham and Dr. Amado, Lena, as well for the invitation. I'd like to thank everyone for tuning in, for paying attention, listening. I've been looking at my emails, and there are people listening. I can say, I think in terms of a final message, in addition to appreciation and thanks, it is that we should view this as an opportunity, not only just a challenge, an opportunity to try and use technology to make the arbitration process work better. Obviously, it requires adjustment and doing things differently. Obviously, it's harder to cross-examine someone when it's harder to see the tribunal, it's harder to control the witness. Obviously, it's more difficult to make submissions to a tribunal when you can't read them quite as easily as you might if things were in person. On the other hand, there are real savings in time and money from virtual hearings. And it's important in a time when in-person hearings aren't possible or are likely not possible, that the wheels of justice, the wheels of arbitration justice, not stop, but instead that we continue, and that we don't just continue, but that we do things better, that we think of ways to make the arbitral process, as those who came before us have done, better, that it provides a better means of resolving disputes than the alternatives. I'm confident that virtual hearings, as well as other uses of technology, enable us to do that, and we should embrace it. With the help of our IT specialists, we should embrace it wholeheartedly. Thank you.
Well, unfortunately for all of us that could be hours listening to you, it is time to say goodbye. So it is my pleasure to very gratefully say thank you for being with us. Thank you for sharing your wisdom. Thank you for letting us pick your brain, for the patience, for being avant-garde in your vision, as you've always been. I think it's very inspirational for many, especially in this part of the world, in Latin America, in which the reluctancy of the profession to the introduction of technology in arbitration proceedings may be a little bit stubborner than elsewhere. And I think it's very inspirational to hear a leader being so stubborn, if you may, on the use of technology and its benefits to the arbitration process and to its legitimacy and efficiency. Thank you also to everyone who joined us today. As I said at the beginning, we are very aware of the many options and alternatives you actually had to these webinars, including cooking or circus or looking or going on a virtual tour to somewhere very remote. So we particularly appreciate that you actually chose to join us. And please stay tuned for our next Arbitration Unplugged webinar from AmCham that will soon be announced. If you missed any part or you want to replay the best moments of this webinar, please be informed that they will be uploaded in, I don't know, I'm guessing in YouTube. So you could come back to us whenever, or if you have any doubt, or if you just forgot what was the ground for trying to deny enforcement of an award, you can come back to us and see it again. With this, I think, as I say, it is time to say goodbye. So thank you again, and see you very soon.
Thank you. Stay safe.
And stay safe, of course. Stay safe.